continue to follow breaking news. The penalty phase for Parkland school shooter Nikolas Cruz has been pushed back once again.
And Local 10's Christina Vasquez has the developing details for us. Christina, kind of surprising here.
Keep in mind that the penalty phase originally was slated to start January 3rd, and then it was supposed to happen February 21st. The state issuing a motion for continuance, essentially telling the judge, look, we still haven't deposed all the witnesses yet. Then the defense actually met the state on that argument. They conferred, they came back to the judge, and they said all attorneys here, all sides say we're just simply not ready. So legal experts say at that point it sort of compels the judge to really listen, as both sides are saying they're not ready for this February 21st date. And so she has now slated the start for the penalty phase to be sometime the first week of April. So all of that now depends on a scheduled status hearing on March 14th. So why the status hearing, not just start the penalty phase, for instance, on March 14th? Both sides telling the judge it can be traumatic for the victims and their families and the community to keep having these shifting dates. So they'd rather just have a status hearing on March 14th and lock down the actual start to the penalty phase after that point, again, to reduce trauma to the victims and the victims' family members. Meantime, what we will all call the jurors that will eventually be seated in that penalty phase, that was a big topic of discussion today.
This is going to be a spectacle.
That's how the defense described their view of Nikolas Cruz's upcoming high-profile penalty phase, asking that potential and seated jurors be referred to by number instead of name.
The publicity requires and dictates that the jurors be protected.
A request to essentially shield the names of jurors who will decide if the confessed Parkland shooter deserves to pay for his crimes with his life.
And that's a lot to ask. They're going to have to view disturbing evidence and hear disturbing testimony. We are asking a lot of them. The least we can do is give them what we legally can give them to be left alone while they have to do that.
The state shot back both in its filed motion and in court today, telling the judge the defense motion lacks merit.
You can't just come in here and ask for relief without meeting standards. They don't meet the standard in Ross, and because of that, the motion should be denied. They say that they've been threatened. Well, how so? Explain it. Provide something.
A perspective echoed by Dana McElroy, an attorney who said she is representing several media outlets, to include the Miami Herald and the Florida Press Association.
As the state pointed out, there is no evidence.
After the judge said she would take what they said under advisement, the defense said they could show the judge and state evidence of threatening contact, but in closed chambers rather than in open court, to shield the names, they said, of minors involved.
Again, the defense wants to have, or seems to be suggesting, a secret hearing.
So where the judge landed on this is asking the defense to essentially file a formal motion, and it sounds like there will now be plenty of time to discuss this matter, because once again, what broke today is that the judge has decided to push back the start of the penalty phase that was supposed to start later this month until she says she's aiming for the first week in April. We'll have more on that once they get to a March 14th status hearing moment. Meantime, the next pretrial hearing in all of this is Monday. Reporting live for you, I'm Christina Vasquez, Local 10 News.
And we know